The Supreme Court of the United States is without a doubt one of the most powerful institutions in the country. It ranks right up there with the Senate, the House of Representatives, and the office of the President. And yet, unlike the other three institutions, the Supreme Court draws its most powerful power not from the Constitution or some sort of other law, but from one of its own decisions. Marbury v. Madison is without a doubt the most important court case to ever be decided by the Supreme Court. The case single-handedly propelled the court from a relatively unimportant branch of government to one of the most powerful institutions in the country by giving it the power of judicial review. What is judicial review, I hear you asking? You probably aren't actually asking that, but just let it work for the video. Well, stick around to find out. Before we get any further into today's episode, I just want to quickly ask that you subscribe and like if you enjoy my content. It really helps the channel out and it motivates me to make more content. Now back to your regularly scheduled programming. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may, from time to time, ordain and establish. United States Constitution, Article 3. The early Supreme Court was without a doubt the least prestigious and powerful branch of government. The first Chief Justice, John Jay, thought the position so useless that he resigned to run for governor of New York. When you look at the history of the court under Jay, it really kind of makes sense. The only case of real importance that Jay presided over in his 5 years as Chief Justice was that of Chisholm versus Georgia. In this case, the court ruled that Georgia must pay two South Carolina loyalists compensation for land that the state had seized during the Revolutionary War. The case would be superseded in just a few years by the passage of the 11th Amendment, which greatly restricted the ability of individuals to bring suits against states in federal courts. The rest of the cases that came before Jay and his court were almost all related to procedural or statutory issues, and thus the court had no real way to carve out any sort of power for itself. This would all change under future Chief Justice John Marshall. Marshall was born the oldest of 15 other siblings in what was at the time the colony of Virginia. Marshall was an ardent supporter of independence and became an active politician following the war. Marshall won election to Congress in 1798 in Virginia's 13th Congressional District. Marshall was a Federalist and thus aligned with President George Washington and Vice President John Adams. In May of 1800, Adams, who had won election as president following Washington's decision to not run for a third term in 1796, nominated Marshall to serve as Secretary of State. However, this appointment would not last very long, as later in the year, Chief Justice Oliver Ellsworth resigned his position due to poor health. At first, President Adams wished to reappoint John Jay back to his old position. However, Jay refused, as the court had been unable to gain any sort of power, and Jay remained frustrated by that fact. Jay's letter refusing to take the nomination arrived only 2 months before Thomas Jefferson, the newly elected president, was supposed to take office. Adams was running out of time and knew that he needed to nominate someone who was not only acceptable to the Senate, but currently present in Washington, D.C., as they needed to be able to appear before the Senate as soon as possible to avoid extending the absence into the start of Jefferson's presidency. The only person who met those requirements? John Marshall. At first, the Senate was skeptical of Marshall. After all, Marshall had not served on any court and was now being nominated to serve as the Chief Justice of what was supposed to be the highest court in the land. Eventually, however, the Senate gave in and accepted Marshall's nomination. New Jersey Senator Jonathan Dayton was quoted as saying, "The Senate relented, lest another, not so qualified, and more disgusting to the bench, should be substituted, and because it appeared that this gentleman," meaning Marshall, "was not privy to his own nomination." In another sign of just how unimportant the position of Chief Justice was, even after Marshall was inaugurated into his new position, President Adams requested him to stay on as Secretary of State until the end of his term. So for a month, February 4th to March 4th, John Marshall was both the Secretary of State and the Chief Justice of the Supreme Court. This would come to be important for Marshall because of a law passed by Adams during the short period following Thomas Jefferson's victory and Jefferson's inauguration. That law was the Judiciary Act of 1801. The act itself is not all that important, as it would eventually be rendered useless just a year after its passage. But what was important was that the act established 16 new lifetime judgeships in the federal judiciary. With only 19 days between the passage of the new act and the expiration of his term as president, Adams quickly appointed judges to all 16 new judgeships. These judges would come to be known as the, quote, midnight judges, as it was said that Adams was signing their commissions at midnight the night before Jefferson took office. Technically, Adams was well within his power to do so, and Jefferson likely would have struggled to do anything to dislodge the newly appointed judges, save for one fact. At this point in American history, it was customary for the newly appointed judges to receive their commission in person. Normally, this wouldn't have been an issue, as the person would have shown up in Washington, D.C. to face questioning from the Senate. However, roughly half of the judges that Adams appointed were appointed on such short notice that they were not present in the Capitol to receive their commissions. This meant that technically they were not recognized as judges quite yet. Upon taking office, Thomas Jefferson instructed his newly appointed Secretary of State, James Madison, to withhold the remaining commissions and thus not allow the judges to take up their position. You see, Jefferson believed that since the commissions were not delivered prior to John Adams leaving office, they were now null and void, and it was up to him to nominate individuals to fill the seats. One individual whose commission was being withheld was William Marbury. Marbury was an ardent Federalist and ally of John Adams, and had been appointed as the Justice of the Peace in the District of Columbia, a position that was actually outside of the Judiciary Act of 1801. In the United States, the Justice of the Peace is typically the lowest-ranking judicial officer on the court, and would typically hear misdemeanor cases. Marbury was very unhappy with his commission being withheld, so unhappy that he sued James Madison in the Supreme Court. Marbury asked the Supreme Court to issue a writ of mandamus, which is an order by the court compelling a governmental entity to do some specific act which it is required to do under the law, and force Madison to deliver the commission. Jefferson, probably either knowing this would happen or having some sort of idea that this would happen, had already begun work on a new Judiciary Act, which would repeal the old Judiciary Act as well as effectively cancel the current Supreme Court term by forcing the court to delay their session to February, some 2 months after the filing of Marbury's case in December of 1801. With the repeal of the old Judiciary Act, all of the judges that Adams had forced through Congress were now out of a job, as their judgeships ceased to exist. However, Marbury still had a case, as remember, his position was technically outside of the old Judiciary Act, and thus the case before the Supreme Court continued. On February 24, 1803, the Supreme Court issued a unanimous 4-0 decision in the case. The opinion was written by Chief Justice Marshall, who based the opinion around 3 questions. Firstly, did Marbury have a right to his commission? Secondly, if Marbury did have a right to his commission, was there a legal remedy for him to obtain it? And lastly, if there was such a remedy, could the Supreme Court legally issue it? Essentially, the court faced the question of whether Marbury was entitled to the position, and if he was there a way for the court to give him that position? The court found that, indeed, Marbury was entitled to his commission. Marshall and the court found that all legal procedures had been followed, and that the commission had been signed and sealed. The court also rejected the argument brought forth by Madison and Jefferson that the commissions were void if not delivered. The court ruled that commissions being delivered was only a custom, not an action of law, with Chief Justice Marshall writing, "The President's signature is a warrant for affixing the Great Seal to the Commission, and the Great Seal is only to be affixed to an instrument which is complete. The transmission of the Commission is a practice directed by convenience, but not by law. It cannot therefore be necessary to constitute the appointment which must precede it and which is the mere act of the President." So point for Marbury. The court had found that he deserved his commission, and Madison's withholding of it was a violation of the legal rights of Marbury. The court then turned to the second question. Was there a legal remedy for Marbury to obtain his commission? Again, the court ruled that yes, there was. Marshall wrote, "It is a general and indisputable rule that where there is a legal right, there is also a legal remedy, by suit or action at law, whenever that right is invaded." Essentially, Marshall said that where there is a legal right, in this case a legal right to the commission, there is a legal remedy. The court ruled that in this case a writ of mandamus was the appropriate remedy for Marbury's situation. This, however, posed another question. Could the Supreme Court, a separate branch of the federal government, order the Secretary of State, an officer in a different branch of the government, to do anything? Well, the court ruled that as long as the writ involved a mandatory duty of a specific person, and not a political matter left to discretion, the courts could provide the legal remedy. So again, another point to Marbury. It's starting to look good for Marbury. He was entitled to his commission, and the court was prepared to issue a legal remedy for him to obtain it. However, the court still faced one more question. Did the Supreme Court have the authority to issue such a writ? The answer depended on how one read the original Judiciary Act of 1789. And wow, the United States government is really good at naming bills. That's 3 Judiciary Acts. Remember that the Constitution only mandates the existence and jurisdiction of the Supreme Court. It does not have any provisions for the composition nor jurisdiction for the other courts of the country. Thus, it was all up to Congress to decide not only the composition of the other courts, but also their jurisdiction. Thus, the Judiciary Act was born. We don't really need to focus on the other courts. We need to only talk about what the Act attempted to do to the Supreme Court. The Supreme Court was given exclusive original jurisdiction, meaning that the Supreme Court would be the first court to hear these types of cases, over all civil actions between states or between a state and the United States, as well as over all suits and proceedings brought against ambassadors and other diplomatic personnel, and original, but not exclusive, jurisdiction over all other cases in which a state was a party and any cases brought by an ambassador. The court was further given appellate jurisdiction, meaning that the parties within the case could appeal to the Supreme Court over decisions of the federal circuit courts, as well as decisions by state courts holding invalid any statute or treaty of the United States, or holding valid any state law or practice that was challenged as being inconsistent with the federal Constitution, treaties, or laws, or rejecting any claim made by a party under a provision of the federal Constitution, treaties, or laws. Now back to Marbury. Marshall interpreted this act as giving the Supreme Court original jurisdiction in cases concerning writs of mandamus. Thus it seemed that Marbury had won the case. After all, the court had ruled that he deserved his commission, that a legal remedy existed to give him that commission, and that the Supreme Court had the jurisdiction and authority to grant such a legal remedy. Marshall, however, did not stop there. Instead, Marshall contended that the original Judiciary Act actually went against the Constitution, as the Constitution specifies that the Supreme Court holds jurisdiction in, quote, all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be party. The Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exemptions and under such regulations as the Congress shall make. Thus, if we read only the Constitution, then the Supreme Court did not have original jurisdiction in this case. However, if we also add the original Judiciary Act of 1789 to our reading, then the Supreme Court did have jurisdiction. There is an obvious contradiction here. Which should the court follow, the Constitution or the Act of Congress? Well, Marshall determined that Congress cannot increase the Supreme Court's original jurisdiction as it was set down in the Constitution, and therefore, it held that the relevant portion of Section 13 of the Judiciary Act violated Article 3 of the Constitution. Talk about a curveball. Suddenly the court no longer had the authority to issue any writ in this case, and they quite simply did not have the jurisdiction to hear the case. The Supreme Court did not stop here, however. It further ruled that since Section 13 of the Judiciary Act, the section listing the new Supreme Court powers, violated the Constitution, it was now null and void. This was the court's first ever use of judicial review. Judicial review in the United States is the legal power of a court to determine if a law, treaty, administrative regulation, or any other such action violates the Constitution of whichever government the court is under. In this case, the Supreme Court decides cases concerning the federal government, and thus determines the constitutionality of cases under the basis of the United States Constitution. But if the case had been before a state Supreme Court, then the state's constitution would be the object to use. I cannot describe to you how important judicial review is to the courts of the United States today. Nearly every single Supreme Court case since Marbury v. Madison has used judicial review in some way. This new power quite literally turned the Supreme Court from a mostly useless branch of the federal government into the final decision maker on the legality of nearly everything that the other branches of the federal government can possibly do. But we'll talk more about that later. Back to Marbury. Marshall further laid out the precedent and rationale for why the court believed it had the ability to conduct judicial review. Marshall writes, "The powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten, the Constitution is written. Certainly all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. And in what has become probably the most famous line of the decision, Marshall writes, "It is emphatically the province and duty of the judicial department to say what the law is." Marshall is essentially saying that the Constitution places limits and checks on the power of the branches of the federal government. I doubt that any American would be willing to argue against this statement. However, Marshall further argues that these limits are useless unless there is a way to enforce them. Thus, Marshall argues that it is up to the courts to determine if the other branches of government have exceeded the authority granted to them by the Constitution. Marshall further argues that it is the Constitution which must reign supreme, as if the courts simply followed the acts of Congress, then the Constitution would become subservient to the laws of Congress, thus making Congress essentially omnipotent. Marbury again justified judicial review by stating that since Article 3 grants the Supreme Court the ability to decide cases, quote, under this Constitution, unquote, it had the power to strike down laws that contradict the Constitution. Lastly, Marshall argued that judicial review is implied within the Supremacy Clause of Article 6 of the Constitution, as it declares that the supreme law of the United States is the Constitution, and laws made in pursuance thereof, rather than the Constitution and all federal laws generally. Wow. The court had just given itself a power, then took that power away, and then gained a much more important and wide-reaching power. And Marbury was now completely out of luck, as the court further ruled that since Section 13 of the Judiciary Act was now void, it no longer had the authority to issue a writ of mandamus. And that is where we will pause our examination of Marbury v. Madison for today. The court had just taken the largest gamble in American history, giving itself an extremely powerful tool that would serve to make the court the overseer of all laws and actions of the federal government. But would that power stick? And what would happen to Marbury? Well, join me next Friday, May the 19th, to find out. Thank you for watching. I hope you enjoyed it and I hope you learned something. This is the first in a new Friday series where I talk about any history that interests me at the moment. I wanted to choose something different from the normal history that has been on the channel so far, so hopefully you enjoyed that. I would love to make this series based around suggestions from you all, so if you have any suggestions or want me to cover a certain topic, comment them down below. Those topics can be anything, from our ancient ancestors like Australopithecus to the history of World War II. If you have any further comments or questions on the video, or believe I've made a mistake, please comment down below. And please like and subscribe if you enjoyed it. It really helps the channel out. Peace.